Good morning. Thank you, Chris. As Chris mentioned, I will be talking about violence and harassment in the workplace. Unfortunately, this seems to be a topic that comes up from time to time in our employment law files. So as you may all be aware, a workplace is pretty much a building, a construction site, a hospital, even an open field. Any type of place, land or premises that a worker is directed and paid to be there can be classified as a workplace. Under the Occupational Health and Safety Act, they do define workplace violence as well as workplace harassment. Workplace violence is the exercise of physical force by a person against a worker that could cause or causes a physical injury to the worker. It could also be an attempt to exercise physical force or statement or behavior that is reasonably interpreted by the worker as a threat. So it's actually quite broad. Examples of workplace harassment are very obvious ones. You shouldn't hit your coworker, you shouldn't throw things at your coworker. Other ones that may not be so obvious are don't send threatening emails, don't leave threatening post-it notes, don't kick the table that they are leaning against. That's all something that the ministry has included as definitions, as examples that would be included in the definition of workplace violence. Now, accidental incidences like you trip over something and accidentally push your coworker on the ground, if someone raises that as an issue, that's not meant to be included under the ministry's definition. Workplace harassment is any coercive, vexatious comment or conduct that is known or ought reasonably known to be unwelcome. So again, very broad. These are meant to include things like just idle gossip, anything that you say that is meant to intimidate, ridicule, bully. These are all things that you should be aware of as an employer or as an employee that a fellow employee could raise an issue about. Now, what does the ministry expect you to do as an employer? You are mandated under the Occupational Health and Safety Act to prepare a policy with respect to workplace violence, to prepare a policy with respect to workplace harassment. They're slightly different, I can tell you that the difference in a second, as well as review the policies as often as necessary and at minimum on an annual basis. What should the policy include? So for workplace violence, it should include measures and controls that are meant to address the risks that you assess in your workplace, as well as measures and controls on how immediate assistance can be summoned in an incident of workplace violence. For violence and harassment, you need to have the ability, a policy in place that allows a worker to report incidences of violence or harassment, as well as setting out how those incidences of violence and harassment are going to be addressed. Now, as an HR professional, what is your top concern? Three things, basically. Proper investigation of employee complaints. If you don't properly investigate, you may be facing a constructive dismissal case. Effective execution of workplace violence and harassment policies. Again, courts have said, which I'll go over in a little bit more detail in a bit, you can have a policy in place, but if you don't do anything about it, it's just as if you didn't have one in place. And then the last thing that a lot of people probably want to know are what are the appropriate consequences if you come up with, if you are faced with that type of scenario. Should you terminate? Should you not terminate? The courts have made some comments with respect to that. So the first case I'm going to talk about is Dissatel in Craft Canada, which some of you may have known. It's actually quite known for discussing investigation. The topic of investigation, I guess. So Dissatel, the basic facts of this case, just a little bit of background, is that Dissatel was in a relationship with his supervisor at some point in time and his supervisor's wife. So there was a situation and he unwisely, I would say, made a comment to a fellow coworker at a bar outside of the workplace, so employer cannot control that. And as any good coworker or friend would do, that friend brought it back to the workplace and told other people, and it became a bit of a situation for Disotell. So he got changed the shifts, like he was no longer working with that supervisor. He got moved to the night shift, and he started to experience a lot of comments from other people, and he then reported to his supervisor at the time about this situation, and the supervisor basically said, just ignore it. Like, it'll go away if you don't pay attention to it. Point number one, not the right approach. So then it kept happening, and then he said, I want to make a formal complaint, and the supervisor basically said that if you file a complaint, I might not support you, and that if it continues to happen, maybe you might get terminated. Just offhand, something like that. So Kraft had a policy. Its harassment policy basically undertook and obliged supervisory staff to maintain an environment free of intimidation or harassment, and to actually respond if someone makes a complaint. So clearly, the supervisor that Disotell went to did not follow this policy. But what the court talked about was with respect to what Kraft did to investigate the situation. So what Kraft did was they interviewed 4 supervisory employees, not necessarily the ones that were actually over Disotell, but they found that 3 out of the 4 supervisory employees had no knowledge of harassment, which is it's not uncommon because maybe they weren't actually the ones who were covering the shifts that he was part of. What they didn't do was they didn't interview the 4 people that he complained about, so the ones that were actually the harassers, and they also did not interview the other individuals at the night shift that could have heard about Disotell's complaints or could have seen incidences of harassment. So Kraft's failure to do that was quite reprimanded by the court in their decision. So what did Disotell do? He went on sick leave, he eventually quit, and then he sued for constructive dismissal. And in his constructive dismissal claim, he said that Kraft repudiated a fundamental term of their contract, which was to give me an environment to work in that's free of harassment. So what was the outcome? He was a 16-year non-management employee. So if you're in HR or employment law, you'll realize non-management employees get a little bit less sometimes when it comes to packages. And he was 36 years of age, which is relatively young. Like if you're thinking age as a factor, usually the older 50, 60-year-olds have a little bit more because they find it a little bit more difficult to find a job. Or at least that's how the court views it. He mitigated, but he didn't find a job that was comparable. And like I said, you can't control what an employee who leaves, how hard they try to find a job. So they could just say, oh, I'm going to work at Shoppers Drug Mart for, $10.95 at the cash. And a court will say, no, that's good enough. They tried a little bit harder. So he got 12 months notice, which was $43,978. And he also got prejudgment interest for 3 years, because that's how long it took from his dismissal to when they actually got a decision. And he also got partial indemnity costs. So companies, don't forget, you still have to pay them interest as well as costs. So getting a decision is bad, but then on top of all that stuff, it's extra money, right, that they get. And this was only because Kraft didn't actually take steps to investigate. So the next case I'm going to talk about, I'm sure a lot of you have heard about. It was quite out there in the media, maybe a couple years ago, and then also the Court of Appeal happened this past January. It's the Boucher and Walmart case. So Walmart had a number of policies. The first policy, I've listed some of them out there. That's their open door policy, open door communication policy. They're encouraged to report on a confidential basis concerns about how stores are operated and how employees are treated. They're also allowed to they tell them that all reports of incidences are taken seriously, and they protect their employee from complaints. That's their workplace violence policy. They also have a harassment and discrimination policy, which says that they will protect their employees from unwelcome conduct that offends personal feelings. So what happened in this case? If you don't know the facts already, basically Pinnock was an assistant manager at one of the Walmart locations. I think it was Windsor. She was doing quite well. She started in 1999, and then in 2008 or 9, she got promoted and she went to this Windsor location, and Boucher was her supervisor, and he wanted her to falsify a log. So consciously, she didn't want to do that, and he said that she was basically insubordinate and needed coaching. So he put her on a coaching plan, and she felt that it was unjustified. So based on the open door communication policy, she went out and made a formal complaint. Unfortunately, Walmart's management didn't necessarily treat that as confidential. So Boucher found out about the complaint, and he started treating her less friendly. He went on this, so first of all, he addresses her and saying, "How dare you make a complaint against me? I'm going to make your life miserable." And then goes on to do a list of things that are set out in the case that goes from, just making rude comments to her on a day-to-day basis, asking whether or not she's competent. And I think the last straw was an incident where he physically grabbed her arm in front of other coworkers and made her count to 10, and started the counting. So that was a problem. She became humiliated. Throughout this period, she did, go see a doctor, and she told her fellow coworkers, but it's not like her coworkers didn't know. They saw it. There were people who made comments to Walmart management, and basically what happened was she made more formal complaints. Nobody was addressing it, and then Walmart, when they decided to sit her down, said that they warned her that if her concerns were unwarranted, that she would be held accountable. Again, not the best words coming out of an HR person that you're supposed to be able to go to. And they decided that her comments were unsubstantiated, and they sort of downplayed her, and she eventually quit. And of course, sued her employer for constructive dismissal. So this case took about 5 years up until appeal, because she quit around 2009, and this decision was in 2014. So what happened in the trial decision? So the trial was held before a judge and a jury. The decision in terms of what she got was, so she got her 20 weeks pay, which was per her employment contract, so that's not disputed. She tried to dispute it and appeal, but wasn't successful because the employment contract said 20 weeks. She got that, and she got paid that. Then she got $1.2 million against Walmart, so it was $200,000 for aggravated damages plus $1 million punitive, and then against Pinnock directly, she got $250,000, which was $100,000 in intentional infliction of mental suffering, as well as $150,000 in punitive. But the Court of Appeal came in and they reduced it. But let me go through this decision so that you can realize that the reduction is that it's good for the employer, but you might not get this every time you go to the Court of Appeal. So what happened for the Court of Appeal was that the $200,000 for aggravated damages, which Walmart said, "Oh, I didn't really do that much, we investigated," and all that stuff, they didn't care. The court said, "I don't think that it's unreasonable. I'm going to uphold the $200,000 aggravated damages award," which was breach of contract, manner of dismissal. They did reduce the $1 million decision to $100,000, but as a whole, part of their reasoning was that the package that Boucher was going to be getting had a compensatory / punitive component. If in other cases where, the interesting thing about this was when they were talking about punitive damages, they mention, the Court of Appeal mentions the Hill and Church and Scientology case, which a lot of people might know about. That case, they had $800,000. That was one of the first big two punitive damages. They also mention Whiten and the pilot insurance one, which was $1 million punitive insurance damages. And the court basically says that, yes, I get that you don't think individuals should get a $10,000 or company should get a $100,000 punitive damages award because they already got some other form of award, like $200,000 aggravated or $100,000. But every time the court awards a punitive thing, they're setting a precedent. And frankly, in this scenario, I don't think it's unreasonable. So based on the language of the Court of Appeal, you need to be wary because this isn't a cap, right? If you have a different fact scenario next time and the facts are worse than this Boucher case, a Court of Appeal or a trial judge may quite reasonably hold a decision that is higher than this amount. So you need to be wary about things that you do as an employer or HR professional that exposes your company to these types of damages. And on top of these amounts, the trial decision had a $140,000 costs award. The Court of Appeal upheld that. And the costs for the Court of Appeal weren't determined. Of course, they say make counsel to make submissions, but I wouldn't be surprised if it was somewhere in that range as well, because appeals cost money as well. So the last case that I'm going to be talking about talks about what someone who actually engages in workplace violence and harassment, how you should be treating them. So Hydra One and Ms. Allen, who was a union member, a lot of these cases that talk about how you should treat them are unionized employees. Basically, she made a couple comments and to her coworker. Her situation was that she did not get along with a fellow coworker. Hydra One did actually split them onto different shifts, but then there was one day where they were both at the same place. And she told someone else, not the actual guy, she told someone else, don't worry about me, I carry weapons. It would really make me feel good to kill something today. It sounds like serious if you were hearing this. So the fellow coworker felt concerned. She made a report to her HR person. And what happened to Miss Allen? She was terminated for cause. The termination letter said that your inappropriate behavior are breaches of our code of conduct, which seems like something, if you were seriously concerned, you would do, and you would paper it like that. So what did the court actually say? They said that, sorry, it wasn't a court, it was an arbitrator. So the arbitrator, but a court would use similar factors, said that in each situation, you have to think of a couple things in determining whether termination is justified. Who was the subject matter of the threat? Obviously, in Miss Allen's situation, it wasn't the person she was actually talking to. Was it momentary or was it premeditated? And how serious was the threat? Telling someone that they're ready to kill someone could be pretty serious. But was there any provocation? Like, is the person actually approaching you, or are they standing from afar? And whether or not there was any discipline history or employment record that raised some concerns. And what are, some of the other, like, economic conditions, or if there's an apology. 9 out of 10 times, from what I've read and dealt with in the past, if someone apologizes, regardless of whether or not how sincere it is, on the first incidences, termination is not justified. What happened with Miss Allen? So she got terminated. The arbitrator found that it was excessive. They said basically that every act of workplace violence or harassment doesn't necessarily warrant discharge. And I'm sure if you've dealt with just cause and wrongful dismissal cases, it's sort of the same theory. Not everything that they do is actually going to be just cause. Just cause is actually quite difficult from the employer standpoint. The Occupational Health and Safety Act does not actually address the nature and the quantum of discipline. So though it says that you have to treat them all seriously, it doesn't really tell you when you should necessarily be terminating some. That's something that you as business professionals and HR professionals should be deciding on a case-by-case basis. Just examples of situations and when cause was actually found or termination was actually found to be justified is situations where there were usually multiple reinstatements, like as in I gave you a chance, you came back and you still continued going on a rampage. Or if you put an employee in an anger management program and then they still come back and they aren't able to control their feelings. They found that those situations, you can justify it after you've given them maybe a chance or two. Single incidences like this case mentions examples of when there was a case where a guy was waiting around for his supervisor and then jumped out at her. That was considered to be not cause, and termination was excessive. There were situations where they sent threatening emails on a continuous basis, but for the past 10 years he had been a good employee. So they found that even though it was targeted at one person for a short period of time, as soon as they found out he was remorseful, then you can't just terminate that person. Unfortunately, a lot of these things do go to arbitration or do go before the courts, and they put the employer on a bit of a higher threshold of trying to prove that it was okay for you to terminate the employee. So as an HR person or employment law professionals, we tend to tell our clients that make sure you document everything, make sure you set out warnings and that they are aware that you've given them warnings, and that every incident that happens, just know that if it were to go before an arbitrator or a court, that you have papered it and that you can justify that you've given them chances, they've come back and they haven't changed, and that they are justifiably no longer properly before you as like a good employee, basically. So that's the end of my presentation. If you have any comments, feel free to ask me questions.